Hi everyone, I'm here with Nicolene and I'm Ines. We are here to talk about law and marketing, how it meets. Why do you have to worry about law when you're doing marketing? Why do you have to worry about marketing when you're doing law? Nicolene, do you want to tell a little bit about yourself, who you are?
Thank you so much for joining me today. My name is Nicolene Schoeman-Law, and I'm an attorney. I'm also a conveyancer and a notary and a mediator. And I do many things, but I'm really passionate about business, particularly online business or tech-based business. And I think this is such a wonderful topic for us to unpack today in some more detail. I practice as an attorney at SchoemanLaw Incorporated, based in Cape Town, South Africa, where we proudly have been serving the legal needs of entrepreneurs for the last 16 years. So really excited to be here. Thank you.
Awesome. Yeah, I know that you have a good passion for entrepreneurs because I've seen you in the entrepreneurial space. I am Ines Rosef-Ingram. I run Pine3 Marketing also out of Cape Town. Passionate about entrepreneurs, helping entrepreneurs to do overall good marketing decisions, enabling them to do so. So upskilling is a big part of what I do as well. And we will discuss POPI today. It is relating also to what is called GDPR in Europe. And it's really important for people to know this because this is relating to compliance. And we found a lot of businesses don't really understand that by having contact details, they need to consider how do they acquire those contact details, how are they dealing with those contact details, are they keeping them safe, or is it post-it notes and sticky notes and you know, all of that kind of stuff. So I don't know, Nicolene, do you want to just quickly run us through the basics about POPI? What is it really about?
So I think if we look at POPI or POPIA, you know, potato, it is our equivalent of the GDPR. The GDPR is the General Data Protection Regulation. That's what the acronym is short for. And basically it binds Europe as a whole at this point in time. It is obviously much older, much more established than our equivalent POPI, and it aims to regulate the flow of information. And we tend to think that this means that it regulates the flow of online information only, but interestingly, it's actually about data as a whole. So we need to, I think, take a step back and look at this from the point of view that we are collecting information about all sorts of people through our interactions every single day. Where do we get it? What is it? And what are we supposed to be doing with it? That's the starting point. I always say it's better to ask what personal information as defined in POPI is not than it is to ask what it is. Because if you look at the Act, the list is so long. I mean, it covers half a A4 page, right? Almost. And it's really comprehensive. But essentially, it's information which can be identified. It's a uniquely identified data point in relation to a living human being or a business, a juristic person. So interestingly, the minute you become deceased, the protection from a South African point of view no longer applies. So it doesn't apply to a deceased estate, for example, which is just an interesting side note point. But it could be something like your name, your photograph. It could be your email address. It could be an opinion you expressed, and you expressed it to someone, not with the intent of it being everywhere else. It was a private comment, in other words. So whatever it is, belief-wise or opinion or contact information, that it can be attributed to you specifically or to your business. That's the most, I think, comprehensive way of seeking to understand the regulation. And then, of course, now that we know what it is, the Act actually compels us to when we are in charge of information that has been collected, right? So information that has been entrusted to us, being the custodian of the information, maybe collecting it from clients or maybe people you're interviewing for potential job or opportunities, or someone you end up recruiting as such, we are responsible to do some things. We call it the 8 pillars of lawful processing, meaning what is expected of us. So we're expected to tell whoever we are collecting information from what we are collecting from them and why we are collecting it. And the Act goes further and says we need to prove that there's a logical, causal connection between what we're asking you to supply and what we are saying we are going to do with it. So there's no sense in collecting your blood type, for example, if you're wanting to enter a premises, right? That's irrelevant to the purpose of entering the premises, just to illustrate the principle. Then we also need to make sure that we're keeping it safe and we're taking reasonable steps to do so. And if you want to contact me to say, Nicolene, you need to update my information, or please don't use it anymore, I need a mechanism to either update or to modify or to delete the information. And then, of course, I can't, and this is the important one, I think, that I want to mention, is that we can't say, I am dealing with your information for marketing purposes, for example, to tell you about the products or services that may benefit you, and then I actually sell your data to someone else, but you didn't consent to that. So if the purpose which we initially collected for changes, we need to go back and treat it as a fresh collection exercise and seek to get that consent properly again once more.
Yeah. And I think that's also so important when you do marketing, because you do actually collect quite a bit of data, or if you're managing customers. And we see when we work with clients that many don't really have control over the incoming leads coming in. How do they handle website submissions, form submissions, things like that? How is that actually handled, and where is that data stored? And how do they deal with customer information? And what you said as well, people have the right to know what kind of information you have stored on them. So now if you have some information in one Excel sheet and in some other information in another Excel sheet, and then you've written down something in a book, and then you took a picture of someone's business card, there's all these different sources of information that will then be very difficult to manage. So if someone then says, I want you to no longer use my data, I want you to delete the data, it will be quite hard if you don't have those systems in place that allows you to do it. And that's often when we talk to clients about having a CRM, for example, a customer relationship management tool. It's really a lot about being in control of your information. So say, why would I need a CRM? Or my business is not big enough. Well, your business will not be big enough because you might get into trouble because you don't really understand your data, and also you can lose out on clients. But in this context about compliance, really knowing, having one central point of information, knowing what you have where, understanding where you're storing customer files. A lot of those things is really, really important. People don't consider it as part of marketing often. And once you then talk about these are legal things, then people start thinking about these 10 pages, small writing. No, that is too complicated. It doesn't apply to me. While the truth is that it does apply.
Absolutely.
Yeah. And I think also people that deal with clients in Europe need to also understand that they have to adhere to GDPR, for example. People dealing with clients in South Africa might have to deal with how they handling that data as well. So it's really about the recipient, their protection, how are they protected by where they are. And online, this can be quite difficult to keep track of what are the regulations. So generally, I would advise people to just be in control of your data. understand what kind of information do you have? Is it relevant information? Who has access to your information? How is that access monitored? For example, so one thing is to have access, but if the passwords are shared left, right, and center, that might not work so well. There was a case last week in one of the CRMs where they've been sharing of passwords, and there's been a data breach. And then obviously there was things that had to be done to correct that, obviously. But it's really relevant for marketers, and it does apply to everyone. The beauty of having information as well is that you can really target people understanding who they are and how did you get the information, and through that make the communication to them a lot better as well. So there's really a win-win to do this. If you know that this person connected through a specific contact form on your website for a specific service, then you know that they're interested in that service, but you can also communicate to them a lot better. So it really makes it a lot easier to be both compliant and do better marketing. Yeah.
Absolutely. I cannot agree more. I think we need to start asking the right questions, first and foremost, about when we are using third parties to help us in this process. For example, you mentioned the CRM system. Which one are you using? Where are their servers located? It's important for you to know the jurisdiction and whether it falls within the European Union or whether it is in South Africa, or if it's in some other jurisdiction. And it's important for you to know this, because if something goes wrong on that level, particularly if we look at the GDPR regulations, it does seem to filter through from a liability point of view all the way to the person collecting it. In other words, you and I, had we not asked the right questions, we may actually be facing some heavy penalties. The GDPR, unfortunately, is quite a heavy-handed piece of regulation, because of the heavy penalties. I mean, beyond a potential prison term, from an exchange rate point of view for you and I, that's the kind of fine that will put us out of business. You know, it's a good couple of thousand euros. And in fact, I'm underestimating it. I think it's more than 100. It's actually closer to the million mark. But the point is, if that happens to you or I mean, it's game over. And potentially many of us would just want to really run away if that happens. But the point is, we need to ask the right questions. Yeah. We need to ask our providers who they are making use of, who has access to. And then I think something I want to touch on is we need to educate our teams. We need to sit down with them and say, so this is not just the sales side of things. This is not just about our customers. It's also about when we recruit new staff, or when we are onboarding a new supplier to our system. We are collecting information literally in a business everyday context, left, right, and center. And statistically, most of the breaches we've seen have actually not been ill-conceived. You know, that there's someone with malice sitting in the corner wanting to hack the system. It's actually sometimes as simple as someone sending out an email or a message to someone other than the person they intended to, or innocently taking a picture in the workplace and there's a reflection of something else or someone else in a mirror or in a window, and that gets us into hot water. So I think we need to see that we firstly do not become the owners of the data we collect, because I think we sometimes act as if we do. Then that's the first mind shift we need to make. And secondly is to have these conversations with our teams to say, what are we collecting? What do we do? What is every single person's responsibility? What does it mean to keep yourself safe from, you know, not having a breach because you've left the device lying around, or your device gets stolen and it doesn't have any, basic security measures in place, or we don't know who is hosting our CRM or who's doing the web hosting. We need to, I think, take ownership of something really practical. There's a reason why data has become such a commodity for many of the big organs, big corporates out there, big marketing machines, as it's valuable, and we need to treat it as such.
Yeah, and I think our goal also is to create a little bit of that awareness. So a lot of people don't understand that it actually applies to them. It's not that difficult to do things to comply, but awareness is obviously the first step. Being aware of the fact that you're sitting on relevant data. What do you need to have in place to be able to be compliant? But also when it comes to from a law perspective, so a lot of businesses will think, anything relating to law is very tough, or now I'm just in a business, or I'm just a small business. What would you say is a minimum, or how would people be able to have access to the help that they need? Like what would be your quick advice on how to identify what you need from a legal perspective, actually?
I think first things first is to see POPI compliance not as a tick box exercise, but as a lifestyle in your business. That we see data, particularly data that doesn't belong to you and I as we sit here today. Anything that we are entrusted with, that we are being entrusted as custodians of that. That's the first step. There's no ownership that is transferred to us when we're collecting information. So see yourself as this person almost being asked to keep something valuable in trust for someone else. And I think that makes a huge difference, because that immediately creates a seriousness in our awareness, and we act very differently. Then we think we need to sit down. Once that awareness has really become part of the fiber in which you look at this, then we need to sit down and see, what are we collecting in our, for example, sign-up form or our onboarding form, and really to critically assess, why are we collecting a phone number or an email address or a next of kin details? Is it really necessary? So I always say less is more. So do a bit of an audit as to what you're collecting from customers or suppliers, or whatever the case may be. And is it really necessary? And if the answer is I don't know, or just simply no, then rather not collect it if you can't say that there's a real purpose in it. And then make sure that where you are getting people to give you the information, that you tell them out forthright, what are you doing with the information? Why are you collecting with it? Is it to include on a newsletter, or is it to market or to telemarket, or is it to include them on your invoicing system, or whatever that is? It needs to be stated in such words, right? And it can be on your online form, it can be a one line, but it has to be crisp, clear, and to the point. And then, of course, that's the first step. Make sure that if you have an interactive website, maybe with these forms we've mentioned, make sure that you've got a decent privacy policy. Those can be quite pricey, but, platforms like ours, Contracts for Biz, does make it available at an affordable rate. And if you feel you want to add something extra because you're in a special industry or a unique industry, then let us do that, and you only fund that, but you still get the advantage of the cost component. Or, once you're done with that, the front-facing, the public-facing part is done. Then I think the next part I would suggest is the training and the awareness in the staff complement, in the team complement. What are we doing once we have the information? Where do we save it? What does our security look like? And if you need to update your employment policies to make sure that everyone knows this is actually quite serious. It's not a willy-nilly must, are we going to debate whether this is necessary or not? This is a real business imperative. And then to have regular conversations and awareness. Sometimes it's really as simple as that. And last but not least, when you are signing anything in terms of an agreement from a supplier, and they will have access to any of your system data or anything like that, you need to see what they will be doing with your information. So now you have to put on the hat of the consumer. And now you are on the receiving end just as much as people sharing with you and entrusting you would have been. And hopefully that makes the process a little bit easier. But at any point, I think if you feel, oh, I don't know where to start, it's good to reach out to an attorney who has a focus on data protection and privacy law, that focuses on that knows their way around all the regulations in the online business environment, which has evolved quite a bit, particularly in the last 5 years. So it's important to choose someone who knows their way around the regulations and to partner with them in a way that it becomes a constant conversation that needs to happen, an adjustment that happens. And as we learn more and as we get more information from our information regulator, that we all adjust and we improve as we go along, because this is fairly new. We need to be honest about that, particularly to South Africans.
Yeah, I think globally it's an awareness that needs to be created, and dealing with a lot of businesses quickly come to the point that they need to market. So they normally go to products and they get a logo maybe made and a name, and then marketing, and then this legal part of things sort of falls through the cracks a little bit. So I think creating awareness for that is at least one of our goals for today. Do you have anything else, Nicolene, that you wanna share on this with the audience?
I think the last bit of the last nugget I would like to leave to everyone who's watching us today would really be to say, when you start the process of integrating the legal side into the marketing side, we tend to think that the legal and the marketing are two very separate sides of the business coin, and there's no overlap between us. I hope that we've challenged that misconception adequately today, and I hope that it will help us see that how we choose to communicate what we bring to the table as a business is important to, of course, be legally compliant, but it's important for you to think about the message, think about the narrative, and once you've started to work through that and you obviously chasing the sales and the revenue, don't forget that the follow through on the legal side needs to happen, but there needs to be an alignment, not only stylistically, but also in the message and the perception, the culture, the feeling, the emotional feeling you want to create. There's no sense in my mind that we do so much good work from a marketing point of view, positioning ourselves, and then we get the sale, and then we hit this person with the scary legal document that completely reads differently to anything else they've been exposed to. And then we wonder, why do we have resistance or maybe a non-conversion on the sale? But we don't talk to one another. And I really hope that as an entrepreneur, if you're listening to us today, you can't look at your marketing team and your legal team as two separate teams. They really need to talk to one another. And if they can't, then you need to look potentially at finding people who would be open to doing that, because I think we are losing a lot of potential in the process of not talking to one another. And we are losing a lot of gist of what this is intended to do for us and why these regulations exist. So let's embrace it. It's good for the client. The client is in South Africa even is becoming more sophisticated and looking for organizations that take data protection seriously. Gone are the days where people don't ask what you'll be doing with the information. That is no longer the position. So I think we need to be aware of the fact that people want to see this. They want to know we are responsible with what we entrust them with. And we need to walk the walk and talk the talk in a consistent manner. Tick the legal boxes, yes, please, but make sure you do it in a way that doesn't defeat the purpose of the relationship you're trying to forge. Because that makes us feel cheated, right? It makes us feel, but this isn't what I signed up to. And that defeats the purpose of business.
It does, and you can end up losing the sale. So we often talk about life cycle marketing, which goes all the way from collecting leads to creating a fans, which is beyond the purchase process. And one of those points is the actual purchase process. We often go in then and look at what does the purchase process look like. And if you have, so one of the things would be, your buttons are all over the show and no one can find them. But also, how is that purchase experience? So for example, a massive legal contract that has some kind of strange language that you don't even know, and you think, I should probably read this because I do care about my privacy, what's happening to my data, etc. It's just so overwhelming. Okay, let me put it on the side. And what happens is you can lose out on sales only by making these unnecessary hurdles with difficult legal documents. So I really, really support that, creating easy, absorbable legal compliance at the same time as you must create easy, absorbable marketing messaging. So I think that's a quite nice one to leave everyone with. So I hope everyone's been listening, got something out of this. If you have any questions, either to Nicolene or myself, feel free to reach out. We love questions. We love entrepreneurs. I know we both do. And we will see you again for another topic.